So, good afternoon. I am chair of the BZA and I am calling this meeting to order. We do have a quorum. I will read this now because we're meeting virtually. The meeting is held in pursuant to and in compliance with ordinance number 20-A16, an ordinance to ensure the continuity of government during the COVID-19 disaster. The BZA members who are electronically present at this meeting are Mr. Ed Robb, would you?
Here.
Thank you. Mr. Kurt Burkhart.
Here.
Mr. John Shepherd.
I'm here.
Mr. Edward Carrington.
I'm here.
All right, we also have present Mr. Andy Herrick from the County Attorney's Office, Bart Svoboda, who is the zoning administrator, James Bowling, who is attorney to the Board of Zoning Appeals, Francis McCall, who is deputy zoning administrator, and Leah Brumfield, who is, Leah, I don't know what your title is. Are you principal planner, senior planner?
I'm a senior planner too.
Senior planner too. Okay. Now I'll read the other part. The opportunities for the public to access and participate in the electronic meeting are posted on the Albemarle County website, on the Board of Supervisors Appeals homepage, and on the Albemarle County calendar. Participation will include the opportunity to comment on these matters for which comments from the public will be received. Okay, so we've done the quorum. And we do have two items for public hearings, but I understand from Mr. Svoboda that both of the applicants, one is AP 2021-003, the appeal of LOD 2021-013, homestays ownership eligibility. And the other item is AP 2022-0001 WNG LLC homestay. We'll deal with the first one, which is AP 2021-003. But before we do that, I understand that each of these applicants are requesting a deferral. And the reason they're requesting a deferral, from what I understand, and Bart, or Mr. Svoboda, I'm going to ask you to explain what's going on here, but I understand it has to do with the Board of Supervisors is contemplating a change to the zoning ordinance. Would you highlight some of these changes and how it may affect these applicants?
Yeah, there is a pending zoning text amendment that we have accumulated some research for over the past year or so, and we're doing some ordinance updates, one of which includes the ability of the resident manager for properties larger than the 5 acres out in the rural areas. So with the ability to go ask the board for this special exception that allows the owner to appoint a resident manager, it would give these particular applicants an opportunity to at least have that ask as opposed to a not. So it would create an additional route for them to accomplish, I believe, what it is that they're trying to do with their applications. So it is up to the applicant on whether or not they wish to defer. Ms. Brumfield is here. She also is handling that particular zoning text amendment. But as far as the deferrals go, that's kind of the gist of it. It gives the applicants an opportunity to make that ask where the current ordinance does not.
Mr. Herrick, is there anything that you'd like to add to that?
No, ma'am. Simply that both applicants, my understanding is, have requested deferrals. And as Mr. Svoboda indicated, there's a zoning text amendment in process. But it's ultimately up to the Board of Zoning Appeals whether or not to grant those deferrals. The county, for its part, has no objection to deferrals in each of the two cases. If the board is inclined to grant
Oh,
those deferrals, there need to be separate votes on each.
Ms. Brumfield, is there anything that you'd like to add? Any information about the ordinance changes that you think is important that we should hear?
Sure. So the current state of the ordinance for the homestays permits the exact thing a resident manager for an LLC in a residential zoned parcel or a parcel less than 5 acres in size. So what this ZTA is doing is actually just making it the same for all parcels in the county to be able to apply for a resident manager. In case it wasn't clear, what this allows is the owner, which is the LLC, can apply for a resident manager, and then the actual individual person who may hold the LLC can act as the resident manager for the LLC. So I don't know if that clarifies anything, but that would permit, in the cases presented to us, the property would still be able to be held by the LLC, and the resident manager would be the person residing on the property.
Do you have a timeline for when the board is likely to hear this?
Yeah, it's currently scheduled for April 6th. And it was previously postponed from March 2nd, actually. It was originally supposed to be heard tomorrow, but due to board scheduling, it was pushed to April. So we do still anticipate it to go on April.
Okay, thank you. Are there any questions, Mr. Robb? Do you have any questions for staff?
Well, my only thought was this matter was discussed extensively, as I understand, when the original ordinance was devised, and that this question was asked and debated. I'm not familiar with the total content or the time spent on the debate, and I suggest it's been debated probably since then. And I'm just not sure that I don't agree with the board's position already. Well, it doesn't matter since I'm a member of the BZA, but I have no objection to extending this at all. I'm just not sure that what other alternatives we have. We could, of course, we could agree to hear it right now. I'm not in favor of that, so I have no further comment.
Okay. Mr. Burkhart, do you have any questions about the ordinance changes for the staff?
No, none at this time.
Okay. Mr. Shepherd, how about you? Have any questions?
No, I support the deferral requests.
Mr. Carrington?
I don't have any questions either and would agree to support the deferral request, and happy to make a motion to that effect if we're ready for it.
I think we can offer up whether or not I think we probably need an official, we do have emails requesting that, but maybe we should get, and I'll ask the attorneys, an official request from the appellant, the applicant for deferral for each of these.
I thought you had that by email is sufficient.
By the email is sufficient? Okay.
Yes, I think in these days and times we're making this decision electronically. Think about it.
I'm trying to stay out of trouble, Mr. Bowen.
Well, you're out of trouble.
Okay. Mr. Herrick.
I would suggest that any motion for a deferral include a date specific to which the request would be deferred. And again, I would also suggest that the motions be made separately, one for each case.
Yes. Did the applicant, is there a specific date in mind?
Madam Chair, I could let you know that representatives for both applications are available for comment if you would like to open that up to them.
First, I'd like to hear from Ms. Brumfield. what makes sense as far as timing is concerned for this to be reheard by the BZA.
Thank you, Madam Chair. The logical date for that would be probably the May BZA meeting, just because the board meeting hearing this ZTA is going to be after the BZA meeting in April. So I believe the BZA would be on the 5th and the board hearing will be on the 6th of April. So the May date would be the earliest logical time.
Okay, thank you.
But maybe you want to consider putting a little more time afterward to, assuming the Board of Supervisors in their infinite wisdom decides to approve this zoning text amendment, then the process is the applicant has to apply under the procedure, and that takes some time. That's what I'd like to get some idea of. And then I assume that if this zoning text amendment applies and they meet the new requirements, it'll be approved, and that will essentially moot the whole process. So how long will that take, Ms. Brumfield? Just wild guess.
Certainly. Scheduling things on the board's agenda generally takes the maximum allowable time, which is 3 months from application receipt to the actual the board actually considering the special exception, just because they are currently scheduled out so far in advance.
So let's say that when are they supposed to hear this? In April?
April 6th.
All right, they approve it, and then they submit an application in April. What's a reasonable time that the board supervisors could hear it?
If you could give me just 1 second, I can look at the calendars because there is a revolving date for executive summary date request.
Of course, the board can go ahead and set this in May, but then we're just going to be doing this same rigmarole, which is kind of crazy. In other words, there'll be another deferral because they have an application before the county. You might want to consider getting a reasonable period of time to schedule this so that the applicants have time to submit the approval and get it heard again by the Board of Supervisors to end the issue.
Yeah, Bart Swoboda, zoning administrator. Both applicants did request dates. And if we would deal with them, we could deal with them one at a time. Application appeal 2022-1 asked for July 5th. This is a special exception. So if the ordinance passes, it would be a special exception. It would not need to go to the PC. So I believe that timetable would be doable. The applicant for AP 2021 has requested May 3rd. So the board may need to discuss the deferral. Either Mr. Herrick or Mr. Bowling can weigh in on whether or not we need to discuss the deferral date with the applicant or whether or not the Board of Zoning Appeals can just choose the date.
So what would you recommend? I mean, this is the second time we deferred. We just don't want to keep doing this. Give us some days that you think would be appropriate so we can be told by staff that the thing has been approved, and then we can the board BZA can act accordingly. It moots it.
What
Well,
do you got, Mr. Carrington? What do you got?
I would just say that as long as there's no problem with multiple deferrals, Mr. Bowling, I agree that let's not get together and just keep deferring things and keep kicking them down the road. But if I were an applicant and didn't know how the board was going to vote in this upcoming hearing, then I would want to be on the first agenda afterwards and defer if the board does indeed provide a path.
All right, well then put it on the May agenda.
Yeah,
I guess I'm suggesting that I don't think there's any problem keeping a May agenda item because if the board does not vote to approve the text amendment, then I would suggest that the applicant is probably interested in coming back before the BZA, but the applicant is here, so we could certainly ask.
Okay, let us go ahead and officially open the discussion on AP 2021-003, appeal of LOD 2021-013, homestays ownership eligibility. And that is the item that the applicant asked for deferral of May 3rd. So Ms. Alley, can you please invite the applicant in unless the board, the BZA has any more further discussion on this, might be good to find out from the applicant what they're thinking about this deferral date. So we are looking at Kelsey Shine.
Sure. Yeah. Good afternoon, members of the Board of Zoning Appeals. Can you all hear me okay?
Yeah.
Yes.
Thank you. So my name is Kelsey Schlein. I'm a planner with Schimpf Engineering. I've been working with Mr. Bradford Manning on this appeal. And I think Mr. Carrington kind of explained that our thought logic in requesting the May 3rd date specifically. We don't know how the board vote is going to go on April 6th. And if the special exception is not an avenue that is a route to pursue to establishing a homestay on Mr. Manning's property, we would like to come back to the BZA as soon as possible after that decision is made, which would be the May 3rd meeting.
Okay.
All right. So is there anything else that you'd like to present at this time, Ms. Schlein?
I have nothing to present this time. Would just, thank you all for hearing this again. And I'm sorry to continually defer it, but I hope that we'll have some clarity on potential alternative routes to take with this application after the April 6th meeting of the Board of Supervisors.
Okay, does anyone else have any questions for Ms. Schlein? No? Okay, at this point, then we will close this public part of the process and ask fellow board members if they have any further comments or questions or suggestions at this point. Mr. Rob, what are you thinking?
I have no further questions related to this subject.
Okay. Mr. Burkhart.
I was just wondering whether or not there's any limit to the number of deferrals that can be given once an appeal has been filed, and whether there's a date certain after, let's say, an appeal has been requested to be deferred, that it will be heard within a period that's time certain, let's say 60, 90 days following that. I'm just curious.
I can start that. Andy may want to jump in, or Mr. Bowling, Mr. Herrick or Mr. Bowling may want to jump in. There's no set amount within the code. What we want to make sure of is that both the appellant or an aggrieved party would have a kind of reasonable time under the law to seek a decision. So in some cases, if there's, say, no objection, I'm not a neighbor objecting to a particular instance. And like in this case, it may be more amenable for the appellant to request more deferrals or not worry about the time so much because they have control sort of directly of this application. It's about their property. Where if I am a neighbor who's objecting that what the zoning administrator decided what was legal on the property next door, and I wanted that resolved, the BZA may want to consider that in granting a deferral, so that particular aggrieved party doesn't have to wait on a decision. So there really is no limit under the law, but we also want to be conscious of due process and make sure that we meet a reasonable timetable to make a decision and we don't delay an applicant in any specific case. We want to make sure we achieve due process.
That satisfies my question. Thank you.
Yes, sir.
Mr. Herrick, Mr. Bowling, you want to add anything to that? We good?
I'd simply add that appellants are entitled to a decision within 90 days unless they request a deferral. That's why I think it's important to consider that the deferral dates that the applicants have requested, because otherwise you're extending it beyond the period that they're requesting. So again, to answer Mr. Burkhart's question, there's not a limit on the number of deferrals, just the legal requirement that a decision be rendered in 90 days unless an applicant requests deferral.
Thank you.
Mr. Shepherd, do you have anything that you'd like to ask, add?
So I think, I don't remember specifically, but there are criteria for granting deferrals. But I think Bart touched on that. You can't use the deferral process to just delay a proper decision on your situation. But that's not in play in this case. I think it makes perfect sense to for us to essentially defer to the Board of Supervisors to make their decision, and then we react after that, if necessary.
Okay, and Mr. Carrington, anything that you'd like to add? You're good? Okay. At this point, it seems to make some sense if someone would like to make a motion to defer this item.
I will.
Okay. You are making a motion to defer AP 21-003, appeal of LOD 2021-013, homestays ownership eligibility property or eligibility slash, to what date?
I believe the date that was mentioned is May 3rd, 2022. If that's not, if I'm incorrect on that, someone please say, step up and correct me, but is that the date I heard? To the
Yes.
next,
That's correct. That would
Yep.
be the meeting date of the May meeting.
yep.
Okay, is there a second to that motion?
I
I
second.
second that. Well, Ed can have it.
Mr.
Yeah.
Mr. Rob seconded.
I second it.
Okay, moved by Mr. Burkhardt, seconded by Mr. Rob. Ms. Ellie, are we good on that?
Yeah, we just need to vote. You want me to go ahead and call?
Yes, please.
Mr. Rob,
Aye.
Mr. Burkhart,
Aye.
Mr. Carrington,
Aye.
Mr. Shepherd,
Aye.
Ms. Joseph.
Aye. Okay, passed unanimously. So maybe we will see you, Ms. Schlein, on May 3rd.
Thank you all very much.
Thank you. Okay, the next item before us is AP 2022-00001, WNG LLC. It's the homestay appeal. And this applicant has appealed to a July 5th, but do we have Mr. Garland? Is he going to join us?
He is. One moment.
Yeah, I'm here.
You've been listening, Mr. Garland?
I have, thank you.
All righty. And I scribbled down on my pad here, July 5th. Is there anything that you'd like to add to the discussion? Is the date still good with you? Please
I
let
would
us.
like to add to the discussion just that if there's not a problem with multiple deferrals, then it, for the reasons already stated, it would make sense for us to go ahead and move our deferral up to May 3rd, because just as the other, it would make sense for us to get going sooner than later. I'd picked July 5th originally, thinking that multiple deferrals weren't wanted, and we try to target a date far enough out.
So just to be clear, you would like to change your deferral date until May 3rd. Is that correct?
That's correct.
Okay. Is there anything else you'd like to discuss or comment on or let us know?
Not at this time.
Okay. Okay, at this point, Mr. Rob, do you have any questions for Mr. Garland?
I have no questions. Thank you.
Okay. Mr. Burkhart, any questions for Mr. Garland?
None.
How about you, Mr. Shepherd?
No.
Mr. Carrington?
None.
None. Okay. If there is no more discussion on this with the public, we'll go ahead and close this. And we'll ask if anyone would like to propose a motion on this item.
I will.
All righty.
I move to grant the deferral request of AP 2022-00001 to May 3rd, 2022.
Is there a second?
I second that.
Okay. Moved by Mr. Carrington, seconded by Mr. Shepherd. Is there any further discussion on this item? If not, Ms. Alley, would you please call the roll?
Mr. Rob,
Aye.
Mr. Burkhart,
Aye.
Mr. Carrington,
Aye.
Mr. Shepherd,
Aye.
Ms. Joseph,
Aye. Okay, so now we know what we'll all be doing May 3rd. Okay. The next item on our agenda is approval of the minutes of February 1st, 2022. Does anyone have any comments on the minutes?
I do.
Okay, Mr. Shepherd, what have you got?
So on page 2, line 46, in the course of discussing the gender of the used throughout the document, Mr. Burkhart is referred to as Ms. Burkhart, and I believe that should be changed to Mr. Burkhart.
Page 2?
Mr. Burkhart. we
Oh,
can-
page,
but you-
page 2 of the minutes.
It's the motion on the last sentence of the second page.
I see that is line 46.
Mhm.
I
Oh,
can make that correction.
kind of ironic, Mr. Burkhart.
Yeah, I'll hold my tongue on that one.
It's-
Looking out for you, my friend.
I appreciate it.
Anyway, okay, with that correction, is there anyone who would like to move to approve the minutes? Or are there any other corrections? Do we have a motion for approval?
Madam
I
Chair,
move that we approve the February 1st, 2022 minutes with the one correction on the second page, line 46.
All right,
second,
all right, Mr. Rob seconds with the correction. Yes, Mr. Rob?
with the correction, yes.
All righty. If there's no more comments on the minutes, Ms. Alley, would you please call the roll?
Mr. Carrington,
Aye.
Mr. Rob,
Aye.
Mr. Burkhart,
Aye.
Mr. Shepherd,
Aye.
Ms. Joseph,
Aye. Okay. Now, with the old business is review and readopt the rules of procedure. Has everyone had a chance to go through that again? And are they now acceptable? Mr. Burkhart, what do you think?
I think they're fine.
Okay. Anybody else have any comments? Do we have a motion to approve the rules of procedure?
I move that we adopt the rules of procedure as amended at our last meeting.
Okay. Is there a second?
I'll
Second.
second.
All right, Mr. Rob seconds, Mr. Shepherd moves. All right, there's no further discussion? Okay,
Miss Joseph, can I ask a question about the
absolutely.
deferral schedule? So this is on page 4. The end of the first paragraph, which is a long one on the top of page 4, talks about deferrals enabling the BZA to make the decision within 90 days of the application or appeal. feels relevant, and I'm just interested in understanding that given our context.
I think that's incredibly important also. And Mr. Svoboda, one of the things that you said is something about as long as the applicant requests the deferral, that it stays within the confines that the Virginia Code expresses in terms of once the application is submitted, you have 90 days to make a decision or ruling on that. I'd ask you, and I would ask Mr. Bowling and Mr. Herrick to also sort of weigh in on that, please.
I agree. That's the correct interpretation.
Yep,
Once
agreed.
the applicant requests the deferral, the 90-day rule is not applicable to the BZA.
Okay.
Right. Are you good with that, Mr. Carrington?
I think I am, and mostly because it just says the BZA shall consider the following factors. And so I guess we can consider it and decide accordingly. I just wanted to make sure that we weren't running afoul of something.
Well,
What you don't have the authority to do is that the applicant wants to be heard, it goes go beyond 90 days. Then the position is that the applicant's position is upheld. You don't act on it. I think that's right, Andy. Do you agree?
Well, I think what Carrington is getting at is if you look at number 5 under the deferral rules of procedure, it talks about Virginia Code section 15-2312, and that's where the 90 days comes into play. That's the procedure.
you're freezing.
Count for the statutory time frame, and they do so under 5 under the deferrals. Did you all hear that?
No, you froze up on
Okay.
it.
I'm sorry, I'm discovering an unstable internet connection. What I was saying was that if you look at number 5 under deferrals, that addresses the statutory requirement for the 90-day consideration. So the 90-day time limit is already built into the deferral rule of procedure under number 5.
Okay. Thank you.
Okay. So I'm trying to, we had the motion and we had a second, and did we vote on this, Marcia? I can't remember because I got all engrossed in,
No.
oh, what's going on?
No, ma'am, we have a motion on the floor and a second on the floor. There was a moment of discussion. Now we are able to vote on the motion that's presented.
All right. Thank you, Mr. Carrington, for keeping us all on our toes. Okay. Ms. Alley, would you please call the roll?
Mr. Shepherd,
Aye.
Mr. Carrington,
Aye.
Mr. Rob. Mr. Rob, you're muted.
Aye.
Mr. Burkhart,
Aye.
Ms. Joseph,
Aye. Okay. Now, next item on the agenda is, does anyone have any new business?
I have a couple of questions, if I could pose them, please, to Mr. Svoboda. It's regarding just homestays in general. I jotted down a few questions. I really don't know the answers to these, so it'd be enlightening to me and perhaps others as well. I was wondering how many approved homestays are currently operating in Albemarle County?
Ooh, that number I don't know off the top of my head, but I can get that for you. I don't know, Ms. Brumfield, if you have a close guesstimate.
I would guesstimate, honestly, they all blur together. I will look that up. I
All
can
right,
get that for you probably in 5 minutes, honestly.
I just have a couple other questions along in the same area. I was wondering if there's ever been a current, if there's ever been a review of current homestays to identify the type of legal ownership, whether it's by private individuals, joint tenancy, trusts, just so that we have an idea, because we've had appeals through with LLCs, and I'm just kind of curious, do we know, basically who owns and operates the parcels?
Yeah, as part of the approval process, in the application, the ownership is identified. There may be some what we would call homestays now, as an example, where before they were called B&Bs, that might be a little bit different, but the way we review the applications now, if an LLC was to apply, then we would inform them under the current regs that if they were on the residentially zoned less than 5 acres, they could apply for the resident manager. If they're not, then they can't, hence the 2 appeals that we have. We have not so what we would have, I know of one in particular that has a LLC that was granted the special exception for the resident manager, but that's the only one I can think of off the top of my head.
That's all I have. I just wanted to be a little better informed on this. Thank you.
Sure. And if I can actually add, Mr. Burkhardt, the B&B permit process before 2019, before August 7, 2019, did permit LLCs. So there are currently operating bed and breakfast permits and accessory tourist lodging permits. I think there's about 150 of those between the 2 types that are approved. And those are allowed to have LLCs, and they're allowed to still continuously operate. Homestays, there are 70 approved homestay permits, and that's only since August 7th, 2019.
Well, when the legislature gave the localities the opportunity to regulate short-term vacation rentals, did they give the localities the option to identify what would be a permissible ownership, such as an LLC or trust, or was that embedded in state code?
There's no specific mention of that in state code, but the broader enabling authority of the legislation allows the locality to mitigate what the perceived impacts of that particular use. And so with the I believe with the LLC, the commercial nature of what a micro hotel and so on would take on, may take on as part of that, was part of the thinking along those lines. That's part of the what we've been looking at in the review of the regulation, is to see how it works and what other things would need to be changed. For instance, the special exception for the 125-foot setback that's in the current ordinance, we're reviewing that also to reduce that down with some screening and not have it have to be a board action, because what we're finding is that as we analyze these uses, there's what is the appropriate mitigation for those particular impacts of parking or noise or things like that.
Thank you.
Go ahead, John.
It might be helpful to the board to the BZA, if when we're closer to the Board of Supervisors meeting, if staff could let us know when it's going to be heard, maybe estimate the time on the, let us know where it is on the agenda, so we could listen to the board's discussion, or also make it easy for us to find, provide the links to the staff report that I'm sure has a lot of this information, background information and a discussion that the board will be considering for those that want to delve into it a little further. There's going to be a wealth of information, I expect.
We can send that out.
Can you tell me if this approval runs with the land?
A special exception runs with the land, yes.
So for-
unless it's conditioned otherwise.
Okay, is it also something that if it's not used in 2 years, it's non-conforming and it's gone?
I don't believe that the special exception carries that same language as a special permit. I would have to verify that.
Okay, just curious as to, because it's a big deal to make that sort of, just in my opinion, not in the BZA's opinion, in my opinion, it's a big deal for the board to make that decision if it runs with the land.
Yes.
The language is not present in the current special exception language about an expiration of 2 years.
That's just never mind. Mr. Carrington,
Does the homestay approval run with the land?
No, it does not.
no, but
Okay, so if the property were to change hands, that homestay application would no longer be valid.
Accurate. The homestay application is more akin to a commercial zoning clearance, where every time the use moves, they are required to get a new zoning clearance. And so if the property changes hands, it needs to have a new homestay clearance. The new homestay clearance may apply with the use of the special exception.
Ms.
Thank
Bromfield,
you.
it's almost like a home occupation. If you get a
Yes.
home occupation, then it's yours. It's not the house's.
Yes, very, very good analogy.
Okay, thank you. Any further discussion on any topics while we've got staff here and the attorneys? Mr. Bowling's going cha-ching, cha-ching. No.
I guess the only thing I'd like to just throw out is would there, during this work session or the Board of Supervisors future meeting, when they'll be discussing this, do you think, Bart, that there's any chance to have language inserted where the code could be amended that would provide clarity to the issue of LLCs and their permissibility as regards to a homestay zoning clearance application?
So the part of the language that, and when you guys, when everybody gets copies of, or we provide you the link and you go look at the revisions, we've done a little bit of restructuring within that code to make it flow a little bit better and a little more understandable at this point, opening up that ask for all the properties that would qualify for a homestay as far as we've gotten. At this particular meeting, when we adopt that, we will likely have some discussion about whether or not we want to take that a little bit further or to the next step. So we're trying to make the incremental changes that are sort of obvious ones, and anything that requires a little deeper discussion, not that we don't want to have it, but that we want to make sure that we can at least affect the change that we can at this point. And then we'll continue the discussion. If there's more clarifiers that we need to put in there, then we can. I don't know if Mr. Herrick or Ms. Brumfield have anything to add to that.
Yeah, actually, I have the proposed text up, and one of the things we do clarify in the new changes is under residency requirements, we require at least one individual owner of the homestay parcel must reside in the subject parcel. So that was a language suggested by Mr. Herrick to clarify that it is an individual who must reside, not the LLC. Is everybody frozen?
No, we're all
Oh.
thinking, we're thinking. So-
Yeah, it would make it clearer for me if it said something about natural persons rather than individual. I would be interested in understanding why that term is different, at least.
Now you're getting into a discussion with that I had with Mr. Herrick. If you have a single member LLC with an owner who's always resided on the property and plans to continue on the property and will be operating the B&B on the property, how does that differ from a trust? When really what you're trying to prevent, and I'm an amateur on this, so staff, please speak up. You're trying to prevent somebody from setting up one LLC, setting up multiple entities throughout the county and operating them as little country cottages, if you will. It's a commercial enterprise rather than a side enterprise. And what as I understand it, what the zoning text amendment does is it kind of gives the Board of Supervisors flexibility to deal with this situation where what you really do have almost a legal distinction without a difference. Call it a natural person or an individual or whatever you want to call it. And some of the dilemma comes in when you get into constitutional law and freedom of speech and whatever, and commercial speech. Corporations and LLCs are persons. So it gets complicated. It comes separating legal hairs to some point, but I don't know if I said anything wrong, Bart or Andy.
Well, I think these are all interesting ideas and interesting suggestions for the board to consider, but I would point out that these are legislative decisions for the Board of Supervisors. To the extent that you will have opinion inputs, you're certainly welcome to share them with the Board of Supervisors, but I would again remind you that these are legislative decisions for the Board of Supervisors rather than decisions that are before the BZA.
Oh, absolutely. And I think all the members of the BZA know that. It's the Board of Supervisors bailiwick to decide this, not the BZAs.
Yeah, I think you're just dealing with a bunch of curious people here, Mr. Herrick. So if there is no new business, then it is time to adjourn so that Mr. Bowling can get where he needs to go. Okay. Do we have a motion to adjourn?
I'll make that motion. I move that we adjourn the meeting.
Thank you, Mr. Shepherd.
I'll second.
All right, thank you, Mr. Rob. Ms. Alley, let's go ahead and call the roll.
Mr. Burkhart,
Aye.
Mr. Carrington,
Aye.
Mr. Rob,
Aye.
Mr. Shepherd,
Aye.
Ms. Joseph.
Aye. Thank you all for showing up. It's the most important thing we do is show up. So thank you.